my cue. Excellent. So before I start, let me get a sense of who's in the room. How many of you are GPs? Okay, quite a few. And how many of you are new practices or have recently joined a practice? Okay, so established. Good. That gives me an idea of where to pitch this. Some would say that what you have in front of you is quite an unusual picture. Lawyer with his hands in his own pockets. I would say that that's perhaps unfair. What I'm hoping to achieve during the course of this talk is to just outline some of the options that are available to GPs and to other medical practitioners as far as setting up the practice is concerned. How do you do it? What are some of the pitfalls that you need to consider? What are some of the advantages and disadvantages of the various forms of setting up your practice, and what you have to think about from a legal perspective? So a practitioner in private practice means a practice where a practitioner works for his or her own account, and, in terms of the HPCSA, the practice of a health practitioner who practices for his or her own account either in a solus practice, so that's on their own, or as a partner in a partnership, or as an associate in association with other practitioners, or as a director of a company established in terms of Section 54A of the Health Professions Act. I'll speak a little bit more about that in a moment. That is an unusual circumstance and not generally what you're going to be dealing with. One of the points is that a practitioner shall use his or her own name or the name of a registered practitioner or practitioners with whom he or she is in partnership. The reason for that, and it's exactly the same for lawyers, you can't unfortunately pick your own brand. You've got to go with the name of the practitioner themselves. And the reason for that is the liability that attaches to the individual practitioners. That goes with the brand. In every instance, private practitioners are required to register their practice with the body of healthcare funders, BHF, who are duly mandated by the Council for Medical Schemes to issue practice numbers, PCNS, to every registered practitioner. That is, I would imagine, the most important number in your practice, because without that, the bucks don't flow in. The PCNS must be visible on all formal stationery, including all billing, documentation, and invoices. I had an amusing situation arise around perhaps unclear billing information. One of my clients contacted me and said, Raymond, I've got a sick note, a medical certificate, and it seems something's off. So I said, no problem, why don't you give the practitioner a call and see what the story is. So they phoned the practitioner and said, hi, we'd like you to check your records, please. Did you see a Mr. Bob Pillay on such and such a date? And the medical practitioner immediately said, no, I didn't. And the guy said, well, how do you know? Don't you have to check your records? He said, I can tell you categorically, I did not see Bob Pillay on that date. I said, how could you possibly know? He said, I'm a gynecologist. And what had happened is somebody had stolen a pad from the gynecologist's office and was selling them for $50 a pop. So it's quite a good idea to have as much information on those things as possible. What I'm going to cover broadly today: what are the legal entities under which a private practitioner registered with the HPCSA or HPCSA under the applicable legislation may operate their private practice? What are restrictions on partnerships and associations? What are the BHF requirements for practitioners operating in the above structures? And how might the billing occur? So those are four broad subjects which I'm going to deal with this morning. I'm very happy with questions. If you want to stop me and ask a question, jump in. Some important definitions in terms of the ethical rules of conduct. An association is a form of practicing where two or more practitioners practice for their own account but share communal assets. So those are solus practitioners, but they have common assets or administration functions. Practitioner is a person registered as such under the HP Act, and can also be a juristic person exempted from registration in terms of Section 54A of the HP Act. Private practice is the practice of a healthcare practitioner who practices for their own account I've actually dealt with this definition already, either in association or as a solus practice. Right. Section 8.1 of the Ethical Rules says, a practitioner may practice in partnership or association with or employ only a practitioner who is registered under the Act and who is not prohibited under any of the annexes to the ethical rules or any ethical rulings. So that's fairly straightforward. Provided that in the case of employment, the practitioner so employed either provides supportive healthcare service to complete or supplement the employing practitioner's healthcare, or is in the same professional category as the employing practitioner. So, for reasons that are not really clear to me, South African legislation frowns on multidisciplinary practices, both in the legal, accounting, and medical profession. That's the state of the law as it presently is. That's quite different in other jurisdictions. In the States, multidisciplinary practices are quite common. The advanced reason when I've inquired about it is to engender a sense of independence. But I'm not sure how legitimate that is. Exemptions, I'm not going to deal with this in any detail. There are circumstances where a private company, that's a PTY limited company, may, where a medical practitioner may, in terms of practice under a private company, a PTY limited company, get an exemption which allows practice under limited circumstances. Typically, medical practitioners practice either as sole proprietors, which I'm going to deal with now, as partners, or in terms of a limited liability incorporated entity. If I'm going too fast, please slow me down. Section 8.3 states that if a practitioner shall practice in a partnership, association, or juristic person only within the scope of the profession in respect of which he or she is registered under the Act. Again, this is to combat multidisciplinary practices. If you have a GP practice, you can't have a physio, for example, practicing in that, under that umbrella. 8.4 provides that a practitioner shall not practice in any other form of practice which has inherent requirements or conditions that violate or potentially may violate one or more of the ethical rules or any annexure to them. So here are the kind of practices that you can get: solo practice, partnerships, associations, and personal liability companies, so Incs. Also franchises. Any of the above who outsource their administration or establish a company to manage their administration is in order, provided that such arrangement is not in violation of the established ethical rules of counsel. One of the challenges I'd like to address this morning is when you studied medicine to heal people. One of the challenges that you face in practice is that you also have to wear a bunch of other hats, and one of those hats is to run an effective business. What I'd like to speak to this morning is how do you make sure that that business runs with a minimum of procedural and administrative hassles and the minimum of risk in terms of liability. And I'm going to speak a little bit about how if you practice in an Inc., that can become a saleable asset and actually generate wealth even if you're not going to be practicing in that entity indefinitely. We'll talk about that. A practitioner, we've already dealt with that. Right, what are the legal entities under which a private practitioner registered with the HPCSA or AHPCSA under the applicable legislation may operate? Sole prop, partner in a partnership, private company, very, very limited circumstances, and personal liability. In reality, you're going to be dealing primarily with 1, 2, and 4. What are the pros and cons of a sole proprietorship? Well, there are no administrative requirements. You set up your practice and you start practicing. So it's an advantage in that it's uncomplicated, it's easy to do. They may operate under their own name or a trade name, they may have employees and may carry on most types of businesses. Obviously, we're talking here about a medical business. The owner acquires all the profits, but also bears all the risk. The advantage of any legal juristic person, as opposed to a sole proprietor, is that there are layers of protection between you and a claim. Limited when you're in a profession, such as law or medicine, but there are still some layers of protection which I'll talk about. It doesn't have the operating expense of other entities because there aren't legislative requirements in terms of bookkeeping and other considerations, except to the extent that you have to make sure that your taxes are up to date and properly filed. Success is dependent on the owner and his creditworthiness and ability to run the business. Let me give you an example of where this can go wrong. If you are married in community of property as a sole proprietor, the sole proprietorship and the joint estate of the marriage are all one, with limited exceptions. And that gets complicated if you have a divorce, if you have a sequestration, if you have a spouse who runs into financial difficulties. If they have a sole proprietorship, that runs into financial difficulties. It's all mixed together, and it can become quite hairy. It's relatively easy to establish as it doesn't have to be registered, but there's no perpetual succession. What do I mean by that? Well, if as a sole proprietor you die, what happens to your practice? Yeah, it's gone. In fact, I've dealt with two cases like this. We've had medical practitioners in a sole proprietorship who have had 5 or 6 employees. The practitioner dies, and everybody runs around and says, well, what happens to the employees? And the answer is, they're no longer employees. Their employment came to an end the moment the sole proprietor breathed their last breath. Any claim that they have for salary, leave pay, any of those things, is a claim against the estate, which might take 2 or 3 years to wind up. So what do you do with the warm bodies next to the cold body? What do you do with them? And that raises some questions, it raises some issues. You have to consider, well, if you were employed as an employee, not a medical practitioner, in a sole proprietorship, and the person died, there's still a whole lot of business that has to be wound up. Are you going to be paid? And if you are going to get paid, is it going to be in 2 years' time? Or don't you need to go and find other work? So sole proprietorship has complications that are not immediately apparent. The owner is taxed in a personal capacity on a sliding scale, depending on the generation of income, between 18 and 45%. So it's actually more than 45%, which I'll show you in a moment. Partnership. This is a very comforting way to practice because you're not on your own. You practice in partnership with somebody else, either one person or more than one person, and you do it as a team event. Very, very attractive way for a for a medical practitioner to practice, because it can be quite lonely out there. Really nice to have somebody in the team with you. There are challenges, which I'll discuss in a moment. In order for a legal relationship of partnership to arise, it doesn't have to be in writing. They have to agree to contribute to a common business, either money, labor, or skill, to carry on business with the object of making profit for their joint benefit. What does joint benefit mean? It means that unless there's an agreement to the contrary, you're going to split the profits down the middle. If there is an agreement to the contrary, it doesn't diminish the obligation on either or both of the partners to still put all of the effort in that's required, even if they're participating to a lesser extent in the profits. What are the pros? Same as a sole proprietorship, not a partnership, that's an error, but with 2 or more owners. It operates a business under their own names or trade name, may have employees, and can carry on most kinds of business. Partners acquire all the profits, but also bear all the risk. There's joint and several liability. What does that mean? If you have a partner who does something sketchy, medically or otherwise, and your partner doesn't have a lot of money, the person who's making the claim can come after you. Because there's joint and several liability. There are some limitations to that. There have been recent developments where partnerships can now sue and be sued in their own name, and there are limitations on the extent to which the private assets of the partners become part of the pot of the partnership, but it's still there. It's just limited to an extent which I will discuss. There are no formalities required. That's helpful. It doesn't have the operating expense of other entities in that it's less formal and less administrative burden. The success, however, is dependent on the partners and their creditworthiness and ability to run the business. There's no separate legal personality and no perpetual succession. What do I mean by that? If your partner dies, the partnership comes to an end. If your partner gets sequestrated, the partnership comes to an end. There are legal consequences that happen as soon as something of significance happens to your partner. It's potentially messy if a partner departs, dies, or is sequestrated, because that results in the dissolution of the partnership. And dissolution of the partnership can get quite hairy because it requires an assessment of the assets and liabilities, it requires a division of profits, and it can be quite a messy enterprise. Partners are each taxed in their personal capacities on a sliding scale, again 18 to 45%. They can litigate in their own name for convenience, although there's still the individual estates of the partners behind that. One of the major disadvantages is that you cannot sell shares or interests in the business. Two parties in partnership, one says, I want to retire, or I want to emigrate, or I want to have a wine farm in the Cape, I'm selling my interest. You can't, because you're it. So you're not accumulating value independent of your own participation in the process. This is for your interest and horror. This is how the tax works. And you'll see that if you're earning more than 1.8 million rand, the tax on that is 644,000 plus 45% of taxable income above 1,800,000. So it's quite an expensive way to practice from a tax perspective. I do not support tax evasion. I'm a massive fan of tax avoidance. If you can, avoid it. Private company. I'm not going to deal with this in any detail because it's a very unusual way for medical practitioners to practice. You have to get an exemption from the board to do so in terms of 54A. I'm not really going to deal with that. There are some pros and cons to that, but it's not really going to be applicable to you. One point, if you do have a 54A private corporation and you practice in that, there's still liability for the individual practitioners. And I cannot emphasize this enough. Make sure that you've got the right insurance in place. Therefore, they cannot hide behind their private company when a patient sues them for malpractice. In the event of a legal claim, the company's structure will not protect a healthcare practitioner from personal liability. Protects it in other ways. Protects your liability in terms of debt. If the corporation, unless you sign surety ships, which you shouldn't, as long as the claim is anything other than malpractice, there is a degree of protection from your individual estate. Personal liability company. This is going to be most of you. It's known as an Inc. or an incorporation or an association. It's similar to a private company, but its memorandum of incorporation must state that it's a personal liability company and the name must end with incorporated or Inc., commonly formed by certain professions such as attorneys, doctors, and accountants. Why is it called personal liability? It's because the individual partners retain personal liability for malpractice. It needs at least one director. I always advocate that you have enough for a tie break, if you can. Two directors, if you have a deadlock, you've got a problem. It can have any number of shareholders. Directors and former directors are jointly and severally liable, together with the company, for the company's debts and liabilities incurred during their respective periods of office. So if you come into an Inc., the Inc. incurs debt, you leave the Inc. If that debt is not resolved during the course of your tenancy or your involvement, that debt follows you around technically until the end. There is perpetual succession in that the death of an individual shareholder is not going to result in the termination of the Inc. But you cannot offer your shares for sale to the public. You can only do so to shareholders in the business. It's a separate legal personality. What's the con? It's stringent and costly formalities to set up. It's not actually that costly. although I would strongly recommend that you get a professional to help you with it. You can buy a shelf company. It's quick, it's easy. You can get a tax person to assist you with the tax registration. It's actually not that hard. Higher business profile, but it must be registered with SIP-C. It protects the business name. So if you start out with Smith Governed at Tabete, and Smith Governed and Tabete over time depart and find greener pastures and other partners come in, you can still retain that name, even though those partners are no longer with the entity. So it has a protected business name, which acquires goodwill in the community. So that's a good thing. It is a greater administrative burden because there are certain obligations in terms of tax and reporting every year. What are the restrictions on partnerships and associations? So partnerships and Incs. They must comply with all the general requirements for a valid contract. Parties to the agreement must have contractual capacity. They must actually reach agreement. What is the biggest challenge, or let me ask it a different way. What is the single most common cause of any dispute between two people? Money. That's a good answer. It's not the right answer, but it's a good answer. All right. Who of you are married or have been in a serious relationship? Sorry? Who's been married or in a serious relationship for any length of time? Okay. You only ever fought about one thing. What was it? There's only one thing you ever fight about. At this point, doctors are clearly more reserved. Usually I have people say, children, sex, money, time. It's all of those things, but it's one thing about all of those things. It's this. Every personal conflict arises, almost every personal conflict arises out of an unmet expectation. You expected A and you got B, or somebody expected A from you and got B. Why is there so much conflict about unmet expectations? Generally because you don't know what the expectation is until it isn't met. Both the person who holds the expectation and the person who's not meeting it. You don't know until it isn't met. How many of you have had this conversation with someone? Why didn't you do X? I'm looking at you. Why didn't you do X? Well, you didn't ask me to. I shouldn't have to ask you to. What do you mean? You should flip and know. How am I supposed to flip and know? And then you have a fight, right? So we only know for ourselves what the expectation is when it isn't met. So how on earth can someone else know it? Even if you do know what your own expectation is, we generally communicate it very badly and often only when it hasn't been met. And what happens, you'll all know this. What happens to your brain when you're in a conflict situation? Prefrontal cortex, fight, flight, freeze, and fawn, shuts down, and your ability to reason, to speak rationally, to communicate effectively, disappears, right? So if you're only discussing expectations when you're in a conflict state, it's a drama. You've got to discuss expectations in a calm and reasonable state when you're not at each other's throats. No veins popping out of your head, no veins popping out of your throat. Voice isn't elevated. That's the time to discuss expectations. Why am I raising that? Because the best time to get your expectations sorted out is right at the beginning of the relationship. Expectations have a life cycle. They're formed, they're not met, they're renegotiated, and that cycle repeats itself until one of the parties says, I'm out. And that's usually because too many expectations haven't been met. So it's really important, if you hear only one thing today, among all this other stuff which is a bit boring, get this right. Clarify the expectations up front, write them down. In the process of writing stuff down, you will realize that actually the clarity that you thought had on your expectations was not nearly as clear as you thought it was. Get that right. Right. Partnership agreements can be concluded orally, in writing, or through the conduct of the partners. However, a written contract is advisable. I would go one further. It's a necessity that it's in writing. Really. Otherwise, you have a he said, she said. It's just a drama. Rather have it in writing. In the judgment of Jobert versus Harry and Company, They set out 4 requirements for a partnership. Each must make a contribution. The partnership should be carried out for the joint benefit of the partners. The object should be to make a profit, and the contract should be lawful. There's an aside which I'll deal with maybe later if I've got time. There's joint and several liability. I've already dealt with these things. Partners own the property as co-owners. If you buy an asset, you each own it in equal undivided shares. In terms of insolvency, the sequestration of a partnership estate is treated as separate from the estates of the individual partners, but once the partnership estate is dealt with, they can then look to the estates of the individual partners. Similarly, if there's a sequestration of the individual partnership estates, once that's resolved, if there's still money owing, they can look to the estate of the partnership. So it's not a complete get-out-of-jail-free card, but there are some limitations. Rule 14 of the Uniform Rules of Court, so that's the High Court rules, and Rule 54 of the Magistrates Court Act provide that a partnership can now litigate, sue, or be sued in its own name, which is quite good. That's a recent development. Partners have the right to share in the profits, participate in management. If you're going to have a contract, write down what that means. If you hear anybody say these words, no, we'll sort it out if there's a problem, don't do that. Deal with management up front. Really, honestly, take my word for it. I'm an employment law specialist. I make more money out of that disagreement on how management works than anything else. Compensation, each has the right to inspect partnership books, and each has the right to distribution of assets on dissolution. Partners have a duty to share in the losses, to make a contribution, to exercise care and skill, to guard against a conflict of interest. How do I go back? To accept and fulfill the obligations of the partnership agreement, to acquire benefits, to account to the partnership, and to make full disclosures of information relevant to the partnership. That's important. No side hustles, which happens in professional partnerships all the time. And then you say, well, it's not exactly what we do. It's not exactly what, no, you've got an obligation to disclose. If in doubt, talk about it. When a partner contracts on behalf of the partnership, they act both as a principal in relation to themselves and as an agent on behalf of the other partners. One of the expectations that you need to clarify up front is limits of authority. You can't have one partner running up liability for other partners without their consent and knowledge. If a third party makes a claim and you say to the third party, well, I didn't know what my partner was doing, the law says tough. By being in partnership, you are representing to the whole world that any decision made by your partner, you're okay with. Partnerships terminate with a fluxion of time. So if you agree that a partnership's going to last for 5 years, when the date comes, it's gone. By mutual agreement, by notice of dissolution, you can tell your partners, I intend to dissolve the partnership. My presentation's having a moment. By insolvency of the partnership or either of the partners. Okay. Personal liability companies. It's got several legal requirements. Honestly, it's not that bad. It's not nearly as much as admin as you'd imagine. It's prohibited from offering its shares to the public, which I've dealt with. Directors will be held liable for knowingly participating or carrying on business in a reckless or fraudulent manner. As soon as you, in the administration of your practice, do something that breaks a law, you have a reckless, trading in a reckless manner. It's already established. Because it's obviously reckless to break the law in the manner in which you practice. So bear that in mind. In my world, in the legal world, we have obligations to register for FICA. which is a pain in the backside. If we fail to do so, there's a 15 million rand fine for each failure. So if my partner, well, my co-director, fails to comply with FICA obligations, that becomes a liability on the company to the tune of 15 million rand. And there's no defense to it because it's reckless. To break the law is reckless. What are the BHF requirements for practitioners? BHF is the Board of Healthcare Funders. You know about this. It's a representative organization to the healthcare funding industry, which medical schemes may belong to voluntarily. Its vision is a member-centric healthcare system that's affordable and accessible to the healthcare citizen. Appointed by the Council for Medical Schemes to administer the issuing of practice code numbers. This is obviously very important because this is how you bill. PCNSs are applicable in South Africa, Namibia, and Lesotho, and promotes a uniform, national, and legally constituted identifier for billing purposes. The practice code is allocated to healthcare providers and is a legal requirement for the reimbursement of a claim either of a medical care scheme or a healthcare service provider. The applicant's licensing or registration is verified with the appropriate licensing authority or body, and those are the considerations. I'm not going to deal with this because it doesn't really impact on you directly, it's just good to know. To get a PCN or PCNS number, healthcare service providers must be registered as an independent practitioner, practice, or agency. You can download it, and you can't use someone else's code to bill. Okay. Every practitioner, in terms of section 53.1, shall, unless it's impossible, before rendering professional services, inform the person to whom the service are rendered, or any person responsible for the maintenance of such person, of the fee they intend to charge. I have never, ever had that experience when going to a doctor. No one's ever told me how much it's going to cost, but it's a legal requirement. Or when so requested by the person concerned, or when the fee exceeds that usually charged for such services, in which case the practitioner shall also inform the person concerned of the usual fee. Let's just go there. Any practitioner who claims payment from a patient shall, subject to section 32, furnish the patient with a detailed account within a reasonable period. You do it simultaneously with the services usually, so that's not a problem. Any patient can challenge that if they do so within 3 months of receiving the account. And there's a professional board to determine and publish the fees used as a norm. The HPCSA has guidelines for the keeping of patient records. I'm not going to deal with that in too much detail. But you do have to keep the billing record separate to the patient records. In conclusion, before I deal with these 4 very important points, how many of you have a will? Most of you. The rest of you, get it now. If you have a will, in terms of which the executor is a bank, go and see a professional and get it done by a lawyer. Banks look after whom? Banks. Banks look after banks. A bog standard, run-of-the-mill, very, very, very ordinary estate that should take 6 months to wind up will take 3 years through a bank. Banks will freeze the deceased's bank accounts and not disperse any money, generally, there's some exceptions, until the L&D account has been registered and finalized. That's a stuff up to your partner. Do not get a will administered by a bank, I beg of you. When do you need a will? As soon as you have contractual capacity, when you're 18, you need a will. Why? Because death is an administrative nightmare. And ideally, what you want is a will that regulates your financial affairs in terms of administration long before you die, and before your practice acquires financial value. So if you want to put shares in trusts, or if you want to have any kind of vestiture in terms of portfolio of investments, you want that to take place long before you die. Because if at a later stage you wake up and you say, hey, I'd love to stick this stuff in trusts, you're going to pay a whole lot of tax on the transfer. So get it done early. So what are the 4 things, this is driving me absolutely insane. What are the 4 things that you need to consider? The first is, your practice is a saleable commodity, unless you're a sole proprietor and unless you're practicing in partnership. If you're in an Inc., it's a saleable commodity. It generates value the longer it goes on and the more money it makes. So start to think of it in terms of it's an investment in an asset. In essence, you sell hours, same as me. It's a stupid way to make a living in some respects. If you can generate value through anything other than hours, that's a good idea. And a very good way of doing that is to have an Inc. and to have shareholding and to have in mind throughout that you're building up the brand of the business, that you can sell the shares in it. Contracts should be concluded when the sun is shining. What do I mean? Everyone is happy and everything is clear and simple. You can't conclude contracts when people are grumpy with each other because they won't agree. I can't tell you how many times I've had a client come to me and say, I'm about to fire an employee. I want you to give them a restraint of trade. And I say to them, what do you think the chances are of them signing a restraint of trade? So, not good. Why? Because we're grumpy with each other. When do you sign a restraint of trade? When you employ them, when they want the contract. The same applies to any other contract. You need to conclude the contract when everyone's happy and the sun is shining. Can I add to that? Your practices are going to employ people who are not medical professionals. It's really important to build the value of the practice, to have good employee benefits in place. I'm looking at Raymond here, who's an expert on that stuff. It's really important to have employee benefits in place. I've found many professionals, attorneys and doctors and accountants as well, although perhaps to a less extent, don't think about pension and provident fund, don't think about any kind of care for their support staff, and when they die or when the businesses are sold or anything like that, the support staff are left high and dry. And it's really important, I would say it's an ethical obligation on medical practitioners and lawyers to look out for the interests of their support staff by looking at things like employee benefit schemes. They're not nearly as expensive or complicated as you think they are. Finally, the practice is a commercial commodity. You must do everything that is required to make sure that it's in place, to ensure that it retains not only its value but its function throughout the entity's lifespan. What do I mean by that? What you do today is going to have an impact on the value and longevity of that entity into the future. It's better to invest the money, the time and the energy to get the structures and the systems in place early so that it becomes less of a hassle later and it starts generating both value and income. That's all I have to say. My time is up. Any questions? Yes, ma'am. Thank you.
Very interesting.
Good.
I see we already have a question over here. Can you just give a microphone?
Hi, Raymond.
Hey.
I think you've skipped the part about my question, but with regards to a partnership, if you have 2 doctors partnering together and they both have practice numbers,
Yes.
how would that work out?
So you bill under your practice number,
Okay.
but the money coming in and going out of the partnership is an asset of the partnership,
Okay.
or a liability, as the case may be.
Can I add to that? So
Sure.
with the PCNS, you can also apply for a group practice number. And then when you bill, you have to just allocate your individual practice number as the treating practitioner. So you have your group practice number on your letterhead, but your individual practice number attached as the treating practitioner in your columns, in your invoice.
That's very helpful. Thank you.
Thank you for the presentation. So, as a healthcare practitioner, I'm an occupational therapist, and part
Yes.
of my work is consulting. So, I'm not an OT in some of my consulting work. I'm consulting as a person with a special interest. In terms of what you've laid out, in terms of the Sole Prop Inc., how does that play out? In my consulting firm, can I be another like PTY Ltd or any other aspect? How do I separate myself from my practice number?
You can do a PTY limited if you get a 54A exemption. I don't recommend that. I think you should do it as an Inc. Because of the protections that it affords you and the ability to generate value in the entity that is independent of your drawing breath. So that's how I would do it.
There's a question.
Thanks for the presentation, great one. My questions are two. One is simple one. Is medical practitioners in private practice obliged to have a practice number for their claims or for any other business they do with patients?
I'm sorry, are they obliged to have a what?
Practice number with PHF.
If you're providing medical services, you are.
For the purposes of
Billing,
medical.
yes. Yeah.
Yeah, because
You're moving the
I am-
mic around.
Sorry. Okay. Not all medical aids, or some medical aids have moved out of PHF.
Yes.
Yes. How do you address that issue? Because they are not in PHF, and why should you have a practice number when you claim a medical aid that has moved out of PHF?
Well,
My
look,
second question is, maybe we park that one, because there was a case where a doctor didn't have a practice number, he was not paid, and he went to court, and it was ruled that he should be paid for the services. The second question is, can you go into partnership as a GP with other specialties
no.
in terms of forming a company, and that company, you are in partnership in the company, but not in the practice?
Oh, okay.
So like a group of
Understand.
medical care centers, like, I don't want to name names. There are many, say, healthcare services.
Yes.
You are in that company as different medical specialties, even other allied health specialties. But you are not in partnership in practice. So you are in partnership in the company. Thank you.
So it depends on the facts. The devil is always in the detail. So it depends on how the structures are set up. It depends on how the practices work. What the rules say, the ethical rules say, is that you can't have a multidisciplinary practice as a medical practice. But what you're proposing is something slightly different, and is pretty much how medical centers and hospitals operate. It's the same kind of idea, but those have their own stringent administrative requirements, and it would have to go through the process to get registration, and either they'll give you the thumbs up or thumbs down. It depends on the facts.
Thank you so much. To add to that last question, I think this is often comes up, especially in allieds, because
Yeah.
the way that we treat patients is through OTs and speeches working together, right? But I think what it comes down to is definition. So
Yes.
at the end of the day, the utility company is actually a property company. Because
Yes.
and then you have to practice in your own account, whether as a sole prop or a partnership or an Inc.
Correct.
And you basically employing the utility services of that,
Yeah.
you know,
And then
broader
usually what
company.
happens is that the employment relationships and other service providers that are non-medical, that is dealt with in the same basis as the property, but the practices are actually separate and distinct. That's usually how it works.
Yeah, so I think like for those of you who want to open multidisciplinary practices, but like you said,
But they're
you have to
pitfalls.
go
You've got to
through,
go through the
and you have
process.
to go through a legal, I mean, like I wouldn't recommend then just setting that up yourself.
Yeah.
Like rather than, consult with someone like yourself to say,
Yeah.
like, can you make sure